Good afternoon, everyone. My name is Ryan Prendergast, and I'm a partner at Carter's. I would like to warmly welcome everyone to our fifth and final webinar of the Carter's 2026 Spring Charity and NFP webinars. Some of you may remember me from our second in April, but we saved the best for last. Details of our webinar series can be found on our website at carters.ca. Did you know the ONCA transition period ended on October 18th, 2024? Did your Ontario not-for-profit corporation transition? Or are you at the mercy of deemed amendments? Do you know what that means? Well, if not, our webinar topic today is ONCA issues after the transition period, practical advice and tips, and is being presented by Jackie Dempshire, my fellow partner at Carter's in our Orangeville office where we're presenting today. Jackie practices exclusively in the area of charity and not-for-profit law, and I know that you are really going to enjoy Jackie's presentation today, as she has lots of helpful insights to share and is always a great presenter. There is obviously significant interest in this topic as we have more than 420 people registered for the webinar today. As is the tradition of our firm, Carter's recognizes that its work and the work of its community partners takes place on traditional Indigenous territories throughout Canada. We acknowledge the 46 treaties and other land agreements that cover the province of Ontario. We are thankful to work and live in these territories and acknowledge the enduring stewardship of First Nations, Métis, and Inuit people who have cared for these territories since time immemorial and who continue to contribute to the strength of Ontario and to all communities across Canada. A link to the presentation handout materials for today's session was sent to you in the 1-hour reminder email you should have received, and the video replay will also be available on our YouTube channel within 24 hours after the webinar. Don't forget to like, comment, and subscribe. The webinar today will consist of a presentation by Jackie Dempshire for about 45 to 50 minutes, followed by 10 minutes of questions and answers. If you would like to submit a question at any time, please go to the Q&A icon at the bottom of your Zoom screen and enter it there. We will attempt to answer as many of your questions as possible before the end of our webinar at 1 p.m. sharp. Please note that while Jackie's presentation is full of useful legal information, the presentation today does not constitute legal advice, and you are therefore encouraged to speak to your own lawyer to obtain advice as necessary. Jackie, now over to you to start your presentation.
Thank you so much, Ryan. I appreciate that. Hello, everyone. Welcome to the webinar from downtown Orangeville. Thank you for taking an hour out of your day to join us, and I hope you'll find it useful. I'm going to share my screen. So as Ryan's mentioned, we're going to talk about the Ontario Not-for-Profit Corporations Act today, some issues after the transition period, which ended in October of last year. I call the Ontario Not-for-Profit Corporations Act either ONCA or the ONCA. So that'll be the terminology that I'll be using throughout the presentation. It's an ambitious set of topics that I'd like to talk about with you today about ONCA. But it's going to be high-level comments. The slides are intentionally dense so that you have a resource to take away after our presentation, to think about, discuss with others as needed, and to determine whether you need to get legal advice in certain areas. So we'll first talk about ONCA at a high level, what its purpose was, talk about new incorporations, and then focus on existing Ontario not-for-profit corporations and how the transition period affects those who haven't gone through it yet. And we'll also talk about the post-ONCA transition period, what you need to know in terms of key features of the ONCA documents, how to navigate the process, and then high-level ONCA provision overview. And lastly, we'll finish up with talking about the Ontario Business Registry, which is an electronic online system for Ontario not-for-profit corporations. And a lot of issues come up for clients as they try to navigate the OBR, as we call it for short. Before I get started, I just want to talk about a little bit of terminology. We're talking today about Ontario not-for-profit corporations. A corporation is a legal person. It's separate and apart from its members and directors who are involved in the day-to-day operations of the corporation. And we're going to use the term NFP or not-for-profit. This is a corporate term to describe a type of corporation which is membership-based and operates on a not-for-profit basis. Now, not-for-profit corporations can have that they're organized that way from a corporate perspective, but they also have an income tax status, and they can either be registered charities, which I'm sure a number of our organizations are that are on the webinar today, or they can be non-charitable but tax exempt. And those non-charitable tax exempt organizations are called NPOs, nonprofit organizations under the Income Tax Act. I'm not going to spend a lot of time on charity law per se. It comes up in a few situations for Ontario not-for-profit corporations. Really going to focus on ONCA at a general level, and then you can review what applies to you and what needs to be customized for your organization. So start first with an overview of ONCA. The statute was proclaimed into force on October 19th, 2021. We waited 11 years for it to be proclaimed into force for a variety of reasons, and we welcomed it when it came. Now, following it being proclaimed, ONCA automatically applied to all non-share membership corporations that had been previously set up under Part 3 of the Ontario Corporations Act, and we call that the OCA for short. Now, there's a few other types of not-for-profit corporations that aren't subject to ONCA, at least for the purposes of this presentation. Share capital social clubs, special act corporations, and corporation sole. We're not going to cover those. This presentation wouldn't apply to corporations that are established federally under the Canada Not-for-Profit Corporations Act, or if they're unincorporated voluntary associations. This is just a slide to show the history of ONCA. It received royal assent in 2010. We waited 11 years till it was proclaimed into force on October 19, 2021. There were some amendments that were made to ONCA after the transition period started, and then that 3-year transition period ended on October 18th, 2024. We're in the post-transition period now. So what was the purpose of bringing ONCA in, and what are some of its key features? Well, as I mentioned previously to ONCA being proclaimed, if you wanted to set up a not-for-profit corporation in Ontario, you need to do it under Part 3 of a broader statute, the OCA. And there weren't a lot of rules, some rules, but not a lot. And the purpose of ONCA is to provide a modern regulatory regime for not-for-profit corporations in Ontario. It's a dedicated statute for not-for-profit corporations, and it enhances corporate governance, transparency, and accountability for these types of corporations. With ONCA being in place, incorporation of new not-for-profit corporations is much more efficient than it used to be. There's a lot of enhanced rights for members in ONCA and increased protections for directors and officers, both between a statutory duty of care that was imposed through ONCA, as well as due diligence and good faith defenses for directors and officers. There's a new mechanism, we'll talk about it a bit later, that distinguishes not-for-profit corporations between those that are public benefit corporations and those which are not. It simplifies the review of a corporation's financial records, and we'll discuss that in more detail at the end of the presentation. And it also launched at the same time the Ontario Business Registry, and we're going to talk about that later. So to understand how ONCA works, you need to understand its framework. And it's comprised of 4 main parts. There's many detailed rules in the Act itself. As well, there are regulations to the Act that fill out some of those rules and allow them to be changed more easily from time to time. And then your own corporation is going to have 2 key documents that are going to implement the ONCA rules. There are provisions in a document called your articles. This is your number 1 corporate document. And then there'll be provisions set out in your bylaws, starting with a general operating bylaw, and then you may amend it from time to time. ONCA was modeled after the rules that are in place for for-profit corporations. And most of the time that works, sometimes it doesn't, but that's the basis on which ONCA was drafted. There's a lot more new rules in ONCA than were ever in the previous OCA statute. And these rules can be complicated. You need to understand what they are and how they work with one another and how to best apply them to your corporation in your corporate documents. And the other thing I forgot to mention at the beginning, this presentation will be good for your organization that you work in or volunteer in mainly, but you're likely involved in a number of other not-for-profit organizations set up here in Ontario. And with this information from the webinar today, it will help you better understand those corporate documents as well. So before we dive into existing Ontario not-for-profit corporations and how ONCA affected them, I want to just talk about new incorporations under the statute. So if you wanted to set up a new not-for-profit corporation now in Ontario, it's a much easier process. You will get incorporation as of right. There's no big approval processes you need to go through anymore. And once you're set up, you will be issued articles of incorporation. You may recall the term letters patent. That was what was used under the OCA. That term has been retired, although it still may come up in your historical documents. Under ONCA, a corporation has the powers of a natural person. It's built into the statute. And what used to have to happen in the past, where you had a long laundry list of power clauses to give authority to the corporation, we don't need those anymore. There's some standard information that you'll include in your application for articles of incorporation. Obviously, your corporate name, which you have to make sure is available to be registered for your corporation. Very important, you're going to set out the purposes of your organization, the DNA, the reason why it was set up and what its purpose is to be. You need official email address, a registered office address, and you will need the names and addresses of the first incorporators. As well, we'll talk about this a bit more as we talk about the transition process, but you also need to include your primary activity code, numbers of directors, numbers of membership classes, and mandatory special provisions. You have to prepare, in addition to your articles of incorporation, an ONCA compliant bylaw when you first set up the corporation, but you don't need to file it with the province. If you forget to do that, and that is not uncommon, what ONCA says is that if you don't adopt a bylaw within 60 days of incorporating, then the ministry's default bylaw will apply to your corporation. So something to be aware of. It used to be in the past that if you set up a new Ontario not-for-profit corporation and it was subsequently going to seek charitable status, it first had to get the public guardian and trustee of Ontario to review and approve its purposes. That is no longer the case. However, the PGT, that's what we call the public guardian and trustee for short, still has to consent to any corporate name that has the word foundation or charity in it. If you're looking for a helpful resource as you navigate incorporating a new not-for-profit corporation, the PGT has a very helpful handbook, and I've included a link here. Some other information to know if you have a new corporation that's going to apply for charitable status. Once you were approved for charitable status and located here in Ontario, you used to have to submit your registration letter to the PGT. That's no longer the case. The only time you'll have to deal with the PGT here in Ontario if you're a charity is if you amend your purposes in the future, and then you have to deal with the issue of the after acquired clause, and I'll talk about that a bit later in the presentation. So let's talk about existing Ontario not-for-profit corporations, the ones that were set up under the OCA. Once the ONCA was proclaimed on October 19th, 2024, it started a 3-year transition period for all of those OCA corporations to bring their corporate documents into compliance with ONCA. That transition process, though, was optional. And what it meant was that if your OCA corporation didn't do anything to transition over to ONCA, either during the transition period or afterwards, it has not been dissolved. You don't need to worry about that. That was a problem at the federal level when we went through a similar process back in 2011 to 14. That's not the case in Ontario. So what happened during the transition period? ONCA said that if you had provisions in your OCA corporate documents that were inconsistent with ONCA, then during the transition period, your provisions would continue to apply and take precedence over those inconsistent ONCA requirements. However, if your bylaws were silent on any matter that was addressed in ONCA, then even during the transition period, those ONCA provisions applied to your corporation right away. we encourage, this is a helpful slide to take a look at after the webinar, but we encourage our clients to complete their transition by preparing new corporate documents in compliance with ONCA. To avoid potential confusion by knowing which provisions were deemed to apply to them right away, trying to work out inconsistencies between your existing provisions and those in ONCA, and with the end result being at the end of the transition period, if you had completed the transition properly, you would have new ONCA documents in place, both articles of amendment and a new bylaw, that you knew complied with all of the ONCA requirements, and there was no need to do interpretation and potentially get into debates. And so you would have certainty and avoid possible disputes in the future. So now we're in the post-ONCA transition period. And I do have a number of clients who have not completed the transition yet. And I meet people or meet clients often or potential clients often who didn't even know about ONCA, still don't know about ONCA. And so they haven't completed their transition. So what does that mean? After October 18th, 2024, if your Ontario not-for-profit corporation has not yet completed its transition process, then the provisions in your existing corporate documents, your letters patent, your bylaws, your special resolutions, they have been deemed to be amended to comply with the ONCA. Now, the problem with this deeming approach is that it's difficult for many corporations, mainly who are run by lay people and volunteers, to know which provisions are deemed to be amended and in what way they're deemed to be amended. So our advice continues to be that while it is optional to do the transition period, the best course of action continues to be to move over to the ONCA and to do it properly by adopting at least 2 new documents, new articles of amendment, and a new ONCA compliant bylaw. But also we recommend a 3rd document, which I'll explain in a bit more detail, called Restated Articles of Incorporation. And in taking this approach, you will know that your governance documents fully comply with the detailed requirements of ONCA. So if you say, yeah, thanks, Jackie, that's great advice, but I can't be bothered. We don't want to bother to go through this transition period. What are the practical concerns? Well, the practical concerns is that every time you look at your OCA corporate documents, you have to look at them through a lens of ONCA. You have to know whether a provision, as it's written, continues to be in effect, or whether it's been deemed to be changed by ONCA, and what those changes are. And often in organizations with lay people on the board, there can be debates about what the changes are, what the interpretation is. So the best course of action is to avoid that, so that you avoid a mess and confusion, particularly if there's a dispute within your organization. So you may be asking, well, I'm not sure whether our corporation has gone through the transition process or not. I'm not even sure if ONCA applies to the corporation that I'm involved in. So the starting point with all not-for-profit corporations is their corporate status. When clients come to us, the first thing we do is we obtain a corporate profile for them to find out and confirm that they are originally established in Ontario, as opposed to at the federal level, or not incorporated at all. And through that corporate profile, we can also see whether they have had articles of amendment issued or restated articles issued. And then we can discuss with them the status of their bylaw. So then we would look at if we determine that they are under the ONCA, we look at their existing corporate documents together with the profile to confirm whether they completed the transition process already. And if it looks like they have, because they've gotten articles of amendment, we need to see whether they fully completed the process. I have had clients come to me when they come in for a different matter, I ask them whether they've done their transition. They say that they have, and they provide me with their corporate documents, and all they give me is an ONCA bylaw. And sometimes it's good, sometimes it's not. But just completing an ONCA bylaw and getting into place is not enough. You also have to obtain articles of amendment, and we'll talk about what goes into that document. The next question is, okay, if you have an ONCA bylaw, or even if you've had articles of amendment issued and you think you've done your transition, have you actually done the transition process correctly? Do your new corporate documents fully comply with ONCA's requirements? And if they don't, then you need to consider if and how to amend them. So I wanted to talk about now, just briefly, the ONCA documents that you will prepare in order to transition or now continue over under the new statute. First, you need an ONCA compliant bylaw. You have to look at your current bylaw, even if you think you've done the transition, and see if there's provisions in it that don't comply with ONCA, or if there's gaps that don't address some of the new rules under ONCA. You may not know what you don't know, and that's why you're encouraged to speak to your legal counsel about these issues. You also need to know how the ONCA rules work. We talked a little bit earlier about the framework for ONCA, but in ONCA itself, there are 3 different types of rules, and you need to know what they are and how to work with them. You also need to know what else is unique about your particular corporation from a governance perspective that should be included in the bylaw. I have clients that come, they bring their OCA bylaws, or sometimes they bring an ONCA bylaw they did themselves, and they want us to tinker with it, to fix it here or there. We generally say it's better to start fresh with a solid template ONCA bylaw, and then customize it for your organization. We find this more efficient and cost effective than trying to amend an existing bylaw. Very quickly, there's 3 types of rules in ONCA. I just referenced them a minute ago, and you need to know how they work with one another. There are mandatory rules in ONCA. These are rules that can't be overridden by the Act or the bylaws. One example of a mandatory rule is that only members can remove directors, and members can remove directors for any reason at any time by an ordinary resolution, which is a majority vote. That rule is mandatory. It can't be changed or overridden. There are also default rules in ONCA. And these are rules that apply automatically to your corporation, even if your corporate documents are silent, but you can override them if for whatever reason you don't want them to apply. An example of a default rule are that there can be board and members meetings held by telephone or electronic means. If for some reason your corporation doesn't want that, it only wants in-person meetings, then you have to override that default rule by expressly setting that out in your corporate documents. And there's also optional rules. These are rules that corporations need to opt into if they want to have them apply to their corporation. An example of that is proxy voting by members, or the ability of members to appoint a proxy holder. That is optional. If your corporation wants that, you have to specifically include proxy provisions in your corporate documents. The other key ONCA document that you need to prepare are articles of amendment. The bylaw alone is not enough. You need to prepare articles of amendment which require your historical letters patent and any supplementary letters patent that you obtained. They have to be amended to comply with the new requirements under ONCA. And there's a few main areas where you have to make these amendments. You need to add in your articles of amendment the number of directors you have, which can be fixed or arranged. You need to add in the number of membership classes you have and their voting rights. You have to add in a new mandatory dissolution clause, as well as both mandatory special provisions and then certain special provisions you need to add in order to trigger mechanisms under ONCA. So the way ONCA works is that you obtain articles of amendment to amend certain provisions in your historical letters patent and supplementary letters patent, but those letters patent and supplementary letters patent don't sort of go away. They're not dissolved or discharged. They continue to exist as amended by the articles of amendment. So you may have a number of documents you have to read together to know your operative provisions. We think it's better to prepare a third document as you go through the transition called Restated Articles of Incorporation. And what the restated articles do is it puts all your operative provisions in a single document that you would use going forward. It's a tricky process to prepare. It's not just filling out forms, but it is a valuable document to prepare as you go through the transition process. And this is just a slide to show you how you read your documents after you prepare the ONCA transition process. So when we were working with clients during the transition process, and even now, if a new client came and said, I haven't done my ONCA transition yet, I want to do it, what do I need to do so? You want to first collect all your governing documents, not just the historical corporate documents that we've discussed, but even governance-related documents like organizational charts and governance policies and manuals. Sometimes there's provisions in there that really need to be in your bylaws. You want to review those governing documents, make sure they reflect how your corporation actually operates. And if not, if they don't reflect your process, what changes do you want to make? And then you need to study the key ONCA features. I've given you an overview of the framework and the rules. And you have to figure out what in your current corporate documents needs to change in order to work under ONCA and be set out in your new ONCA documents. You're going to have articles of amendment prepared and ideally restated articles. You're going to prepare your new bylaw. Likely there'll be a few drafts of that. And once they're in final form, they're going to go first to your board of directors to review and approve, and then to your members to review and approve. If you have a broad-based membership, you may have to have an information meeting or two to introduce these new corporate documents to the members so that they understand them and they can ask questions. And then you can schedule a meeting for a formal vote. You're going to file the articles of amendment with the province, who will issue a certificate of amendment. And once that's done, if you're doing restated articles, you do that as the second step in the process and get them issued by the province. As I mentioned, you don't have to file your bylaws with the province. But if you are an Ontario not-for-profit corporation that's also a registered charity, you have to file the full set of ONCA documents with the Charities Directorate. So just at a high level, I wanted to go over some specific provisions that ONCA requires not-for-profit corporations to address. And as you look at your bylaws, you may want to see if these issues are covered in what you've prepared. ONCA corporations have to be membership-based. Now, you can have a very small membership that's the same people who serve on the board, or you could have a broad-based membership, but you must have members. The default is you have to have at least one class of members, and if there's just one class of members, they all have to have the ability to vote. You can, though, have two or more classes of members, and they can have different rights from one another, but at least one of those classes in a multiple class structure have to have voting rights. The bylaws will then have to address the conditions required to become a member, qualification requirements, admission process, and so on. Membership will terminate on death, resignation, removal from membership, or expiration of a membership term, or on the dissolution of the corporation. ONCA does allow a corporation to decide whether the directors or the members as a whole or even a committee is going to be responsible for disciplining members or terminating their membership. But this has to be done acting in good faith and in a fair and reasonable manner. There has to be notice given to the member to be removed. They have the right to respond before a final decision is made. Looking at membership meetings, there's two main types of membership meetings. There's annual meetings, where the members have to meet within 18 months of a new incorporation, and then every 15 months thereafter. So usually you have an annual meeting once a year. And you have to hold that annual meeting no more than 6 months after the year end of the corporation. Then from time to time, there may be special meetings that are called of the membership, and that can be done by the board or the members themselves, representing 10% of the members who have voting rights, can requisition that a special meeting be called. And if that's done correctly, then the board has to call the special meeting. Under ONCA, notice of members' meetings has to be given during a period from 10 to 50 days before the meeting. The default rule is that meetings of members can be held by telephone or electronic means, But if you are holding a meeting this way, you have to make sure that the notice contains all the instructions on how to attend, participate, and vote at a meeting of this kind. And all members have to be able to reasonably participate in the meeting if it's held by phone or electronically. Don't have a lot of time to talk about enhanced members' rights under ONCA. There's a list here for you to look into. Members at the annual meeting do three main things. They will review the financial statements from the year before. They will appoint the auditor or the person doing a review engagement and deal with the level of financial review to be done. And they will elect directors as is required in that particular year. There's a new mechanism under ONCA for members, and that's called proposals. And members have the right under ONCA to submit proposals to do a few things. One, to amend the articles or the bylaws, and that can be done by one member on their own, or to require any other matter that the member wants to be on the agenda of the annual meeting to be added. As well, members, but you need 5% of the members, can submit a proposal to nominate directors to the board. The rules to submit proposals under ONCA are pretty complicated. So whether you're a member wanting to make a proposal or you're on the board of a corporation that receives a proposal, you'll want most likely to get legal advice to make sure that you're doing it properly or dealing with it properly. There's also some broad remedial powers for members who can bring certain types of court applications in relation to the operations of the corporation. But there's not a lot of time to discuss that in any detail. So I'm going to move on to directors. In addition to having members, obviously you need to have a board of directors within your not-for-profit corporation. And their job is to manage or supervise the management of the corporation's activities and affairs. You have to have at least 3 directors for an Ontario not-for-profit corporation. And that's the case whether you're a charity or you're not. You can have a fixed number of directors set out in your articles, or you can have a range, which is a minimum and a maximum number. If you go with the range, which gives you more flexibility, then each year at the annual meeting, you just have to decide what the actual number of members is to be in that year within the range. It's possible under ONCA to have what are called ex officio directors. These are people who become directors by virtue of holding a different office. For example, when the president becomes the past president, you can make them an ex officio director without having to go through an actual election process at the annual meeting of members. There's some mandatory qualification requirements for directors set out on this slide. You have to be 18 or older, you can't be incapable of managing property, and you can't be in bankruptcy. So we mentioned what happens at annual meetings of members. Members will elect the directors as needed each year. The term of office of an elected director can be anywhere from 1 year to a maximum of 4 years. You set that out in your bylaws. You don't have to impose a maximum number of terms on directors, but you can if your corporation wants to put that in place. Under ONCA, directors have to consent in writing to hold the office of director. And so we prepare template consents for directors to sign as they come onto the board. Directors are not to be remunerated in their role as acting as directors. It is possible to receive reasonable remuneration and expenses for any services that directors perform for the corporation. Moving over to directors' meetings. One of the key things here is the default rules that meetings of directors can be held by telephone or electronic means. Again, you have to provide instructions and make sure that everyone attending the board meeting is able to communicate with each other simultaneously and instantaneously. Members don't have the right to attend board meetings, although directors have the right to attend members' meetings. And an issue that comes up from time to time is while members can appoint someone as a proxy to represent them at a members' meeting, the same is not the case for board meetings. Directors must attend directors' meetings on their own. They can't appoint proxies or delegates. You can't have 2 people sharing one director position. There's fiduciary duties that come with being directors of not-for-profit corporations, and you have to exercise them by attending the board meetings yourself. Important thing to bring to your attention in the first circle here is under ONCA, directors who are not present at a meeting are deemed to have consented to any resolutions or actions that were passed at a board meeting unless they dissent in writing and submit it to the corporation within 10 days of becoming aware of that decision with which they disagree. Moving now to a new mechanism that's set out in ONCA, and that is categorizing Ontario not-for-profit corporations as either public benefit corporations or non-public benefit corporations. We call them PBCs or non-PBCs. A public benefit corporation is a charitable corporation. So if your not-for-profit has charitable status with the Charities Directorate, then you're a charitable corporation. Or if you're not a charitable corporation, but you receive more than $10,000 either through gifts or donations from people who aren't members or directors of your corporation, or you receive grants or other financial assistance from any level of government, then your non-charitable corporation will be a PBC. Charitable corporations are automatically PBCs, but for non-charitable corporations, determining whether you're a public benefit corporation, you figure that out each year depending on your revenue level the year before, and you do that on an annual basis. Now, why is it important to figure out if you're a public benefit corporation or a non-public benefit corporation? Well, PBCs have a more stringent financial review requirements under ONCA than non-PBCs, and we'll talk about the details in a minute. As part of that more stringent financial requirements, an audit will be required unless you are able to get a waiver of both the appointment of an auditor and the carrying out of an audit, depending on your revenue levels. There's also restrictions on the composition of the board of directors of a PBC, as well as on how the remaining property of a PBC is distributed in the event of its future dissolution. I won't go into any detail, but the next two slides set out the audit rules for public benefit corporations. You'll see, depending on your gross annual revenue in a particular year, it drives whether you have to do an audit or there's the ability to dispense with those requirements upon members' approval by extraordinary resolution. And then you'll see the audit rules for non-PPCs. The revenue level increases a fair amount in relation to whether you have to appoint an auditor and what type of level of financial review you do. So now let's move to some governance-related issues for you to consider as you either review your corporate documents or start to go through the transition process. As part of looking at your corporate documents, you want to take a look at your objects. They're actually called purposes now. These are the reason why your organization has been set up, and it provides your corporation with the corporate authority to do all of its programs and activities. Often with historical corporations, they were set up with certain purposes that may or may not fully reflect all the programs and activities that they do now. And if that's the case, your corporation will want to consider whether it wants to update its purposes as part of its ONCA transition process. And you would do that by including new purposes in your articles of amendment. There are some issues that a charitable corporation has to deal with if it's updating its purposes. What happens here in Ontario is that if you amend your purposes and you're a charity, ONCA will insert what's called an after acquired clause into your articles of amendment unless the PGT consents to waive that clause being included. And this is important to know about because if you change your purposes and the after acquired clause is put in, then you can only use funds that you receive after the new purpose is in place to carry out that new purpose. And you have to use all your existing money for the existing purposes. The PGT has been reasonable in providing consent and waiving the inclusion of the after acquired clause as long as you're not putting in something completely brand new from what you had before. Some other issues to think about in relation to membership is whether you really need to have multiple membership classes if this is what your corporation does. Often there'll be non-voting classes, or there'll be classes that have a vote that don't really need it. And as part of preparing the ONCA documents, we sometimes simplify those membership classes that may be in place. You may want to review the size of your board of directors. Sometimes we have corporations that come in with boards that are 30, 40 people. Usually that's not ideal from a good governance perspective, but also having a board that's too small is not ideal. As I mentioned, you have to have a minimum of 3. We think a good size of a board is a minimum of 5 up to a maximum of 9 to 12, but you have to, review your organization and what works best for them. You may want to revisit the term of office for directors and the maximum term of office. And you need to be aware of directors having to consent in writing to become directors. One important change, and it comes up a lot in looking at clients' corporate documents, is under ONCA, members are permitted to remove a director for any reason at any time by ordinary resolution, i.e. a majority vote at a properly called members meeting. Often when I'm looking through bylaws where the client has said they have completed the ONCA transition, I will look and I will find a number of bylaw provisions that don't reflect ONCA's requirements. And one of the consistent ones that comes up is that many bylaws will still have a 2/3 vote requirement to remove a director, and this isn't consistent with ONCA. In relation to members' meetings, we've talked about some of these issues already. You have to hold your annual meeting within 6 months of the year end. There's certain mandatory business to be done at annual meetings. One thing that we talk a lot about when we prepare new bylaws is quorum requirements for members' meetings, particularly in a broad-based membership structure. Quorum means the minimum number of people you have to have in attendance at a members' meeting in order for it to proceed. You don't want to set that quorum requirement too high or too low. If it's too high, then you may not be able to hold your meetings consistently. If it's too low, then a small group of members may get to make decisions that could impact the organization. Proxies are optional under the ONCA, but they are complicated. So if you want to include them because that's part of the history of your particular organization, that's fine. But you need to know that the rules are much more complicated under ONCA than they were under the OCA. And you need to prepare a proper written form of proxy that complies with all of these detailed requirements. I'm not going to spend a lot of time on conflict of interest, but under ONCA, directors and officers have to disclose to the corporation if they're a party to a material contract or transaction that the corporation's considering entering into, or if they're a director and officer of a separate corporation that is going to enter into a material contract or transaction with the corporation. If you are a director and officer and you're in a conflict, then you can't attend any part of the board meetings at which the contract's discussed, and you can't vote on the resolution to approve. If your Ontario not-for-profit is also a charity and you're a director that's in a conflict, then if the board decides to proceed with that material contract that you have an interest in, then you have to resign from the board unless you fall into one of the exceptions that are set out here on the slide. That's either an exemption under the Charities Accounting Act or by obtaining a formal court order. Cross appointments between two or affiliated organizations can lead to conflicts of interest, and so you may want to rethink that if you're doing your corporate documents over again. May rethink that type of arrangement. I'm going to skip over remuneration of directors and just talk about officers. So ONCA does require each not-for-profit corporation to have a director who is appointed the chair of the board and must carry out the duties of the chair in accordance with the bylaws. Now, under the old statute, the OCA, they use the terminology of president. And so there's a lot of corporations that have a president and vice president who are board members. And under ONCA, in order to avoid some issues in filling out the returns under the Ontario Business Registry, which likes the term chair, I've had a number of clients move over from using the officer term president to chair, and it makes their life that much easier in dealing with the OBR. But if you want to keep president, you like that term for that officer position, we can include wording in your bylaw that makes the connection between president and chair as required under the Act. So the last thing that I want to speak to you about is the Ontario Business Registry. This was an online filing system that was set up and was launched at the same time as the ONCA. And there's a few, overall, it's been very good for Ontario not-for-profit corporations to be able to access and do their own filings themselves, as opposed to have to use a law firm to do it or a third-party agent. But there's some tricks to it, and I wanted to talk about those here. So with the launch of the OBR, all Ontario not-for-profit corporations have to have an official email address. And this is the address to which the province will send notifications related to the corporation, including the company key. You want to have an address that not everybody in your corporation can access, but at least one that is being checked regularly by someone within the corporation. And you will include that official email address in the Articles of Amendment if you haven't already prepared them. All Ontario not-for-profit corporations, in order to work within the OBR, have to have a company key. This is a 9-digit number that the province provides to all corporations, and that allows you to access the OBR and your corporation's account in order to do your filings as needed. And there's some tips on this slide if you don't have a company key, how to get it, making sure that your official email address is up to date, as well as your registered office address. There's also a need to include your primary activity code for your corporation in the Articles of Amendment. Sometimes it's easy to find the right code, sometimes it's more difficult. There's a link here that explains that process. And then I wanted to finish off by talking about annual returns and notices of change. At the beginning of the presentation, I talked about pulling or obtaining a corporate profile for each Ontario not-for-profit corporation to make sure that it's active, make sure that it's set up in Ontario, to see whether it completed its ONCA transition through Articles of Amendment. But I also check the corporate profile to see the state of the filings of the corporation, whether it's filed its annual return each year, and whether its directors and officers are fully up to date. Now, an annual corporate return is due within 6 months of a corporation's financial year. It's filed with the province, and it makes changes to the officers and directors' information and any administrative information. You do that, you fill out the annual return annually. There's also a document called the Notice of Change. And so between annual meetings and between the filing of your annual returns, if there's changes in your board, directors resign, new directors come on, the officers change, you file a separate document called the Notice of Change, which is required to be filed within 15 days of that change in the OBR. And there's some links here if you want more information about annual returns, what goes in them, how to file them, as well as notice of change. So I will conclude with just some key takeaways from our presentation. The governing documents of Ontario not-for-profit corporations which didn't transition over to ONCA before October 18th, 2024, all of those governing documents are deemed to be amended to comply with the ONCA. But this deeming approach can lead to a lot of uncertainty. So if you haven't done your transition yet, you should consider doing it as soon as possible. There's many rules now under ONCA than there used to be in the past. And you need to know what those rules are, how they apply to your corporation, what your options are, so that you create corporate documents that both reflect the requirements of ONCA, but reflect your organization's unique governance structure. And if you haven't been working within the Ontario Business Registry, I would encourage you to become proficient with the ability to use the online services that are there. You can always ask your legal counsel or other third-party service providers to help you, but I have a lot of clients who are like the ability to do their filings through the OBR on their own. So thank you for your attention. I hope you found this helpful, and good luck. I'm available now to answer any questions, and I'll stop sharing my screen.
Well, good luck is right. Thanks very much, Jackie. That was a wonderful presentation. I'm sure there might be a few people out there that think, what's the big deal? We've got a new bylaw, we're all set. But I think, as you've sort of shown with lots of practical tips and advice, that there can be a lot more to it. So thanks very much. So no surprise, we have a few questions.
Okay.
But Jackie, you did end with talking about the OBR, which, I'm sure there are a lot of organizations just grappling with trying to figure out new legislation and not necessarily the government's new portal as well. And might be learning a few things too from that standpoint. So what happens if an organization might not have been filing annual returns or making use of the OBR at all over the years since the ONCA came into force and since the transition period ended?
Yeah, that's a very good question. As we were doing many ONCA transitions for our clients in pulling the corporate profile, it was not unusual to see 5 years, 10 years of annual returns not being filed, having lists of directors and officers on record with the province that are very outdated. So for some clients, we would try to go back and recreate the annual returns for all the years in the past. That was a lot of work, and frankly, I'm not sure it's worth the effort. The main thing is to bring your corporate records up to date through a notice of change, and then make sure that you're doing your annual returns every year within 6 months of the annual meeting, so that everything is up to date going forward. This is a public record of who are the directors and officers of the corporation, so it's very important to make sure that that's up to date at all times.
Terrific. Well, thanks, Jackie. And we've got some more coming in. So folks, we may not be able to get to everything, but we're going to try to answer as many as we can. But a good question that just came up to clarify that, Jackie, is the annual return you're talking about the same as your T3010?
No, it's not. They're two different things. Remember at the beginning, we talked about there being two different levels that Ontario not-for-profit corporations would have. There's the corporate level. That's what the ONCA covers, and that's where you do your annual returns that are filed with the province. Then at the tax level, you're either a charity or a nonprofit organization, and you will have separate filings that you do with the CRA. As a charity, you file what's called the T3010. It's your annual charity information return. And if you're a nonprofit organization for tax reasons, then you file a T2 with the CRA. You used to be able to update your directors with CRA and they would file it with the province. That stopped many years ago. You have to do those separate filings yourself. And one reason why it gets confused is when you file your T3010 as a charity, they also want to know who your directors are, but there's no connection with the filings you do at the corporate level in Ontario. They're two different things.
Okay, terrific. And maybe one or two other OBR questions. So this is a nice one where we know of an organization that had their OBR key compromised and the directors changed without knowledge. What advice do you have to protect the key, and to recover the account with the government?
Wow, yeah, that's tricky. You can always keeping the key secure, not including it in public documents. If you're circulating a copy of the Articles of Amendment in draft form, you don't want to include the company key there because that allows anybody potentially to access the corporation's records. You can, if something's been compromised or you're not sure, a lot of corporations also can't find their key, you can request a new one from the province through the OBR. The situation where someone has gone in and changed the directors in an unauthorized way, that's more complex than can be discussed today. But yeah, I would encourage that organization to get some legal advice and or speak to the ministry at the province to figure out what to
Absolutely.
do.
Yeah, that's a tough situation.
Mhm.
We also have a number of questions dealing with financial review,
Mhm.
which are fun. But for example, like I've had someone reach out to me recently where they talked about they had a $15,000 quote for an audit. So, can't you, Jackie, just put in your bylaws that you don't want to do an audit?
Unfortunately, no. Ontario not-for-profit corporations, even under the old statute, the OCA and the ONCA, always had an audit requirement imposed on them. It actually is a corporate requirement that's imposed on them as opposed to at the tax level with CRA. Um, the good thing about the ONCA versus the old statute is that there's higher revenue thresholds where you may or may not be able to get membership approval to exempt you from appointing an auditor or carrying out an audit versus a review engagement. So those charts that are in the PowerPoint are very helpful to map out the different revenue thresholds depending on if you're a public benefit corporation versus a non-public benefit corporation. Just trying to opt out in your bylaws doesn't doesn't get rid of that requirement. ONCA superimposes that requirement on all corporations.
Okay, perfect. Then there's a few questions about ex officio directors. So with ex Jackie, do ex officio directors have voting rights? Can an ex officio director be an employee of a corporation?
Um, Ex officio directors, you want to be careful with directors. Whoever is a director, whether an elected director or an ex officio director, they will have voting rights. So sometimes I see bylaws where they'll have honorary directors and they don't have any voting rights at board meetings. And I say you can't do that. That's not good for the director. It's not good for the organization. Um, all directors need to have voting rights, and ex officio directors will have voting rights. It's generally not a good idea for employees to be directors of an organization, and frankly, it's not possible where your Ontario not-for-profit corporation is also a charity. You can't have anyone on the board of an Ontario charitable corporation that's being paid as an employee. That's prohibited unless you have a court order.
Hmm. Okay. Thank you, Jackie. And so speaking on the topic of directors, so not ex officio directors, but is there a maximum term for a board member that the member can stay on the board, even if they didn't do any good for the charity?
Well, you really have to back to your bylaws and see what they say. ONCA says that a term of office for a director can be anywhere from 1 year, 2 year, 3 year, or 4 year. You get to choose that and set it out in your bylaw. The term of a director can't be any more than 4 years. But at the end of the 4 years, depending, or whatever the term is, depending on what your bylaw says, those directors could be reelected. So that's where the concept of a maximum term of office comes from. And there's pros and cons whether to have a maximum term or not have a maximum term. Um, but if you have a director who's not doing a good job, then you have terms of office where they would be up for your reelection potentially and not be elected. They have maximum terms of office where if they reach the maximum term of office, they could come off. And there's also rights for members within a not-for-profit corporation to remove a director who is not doing a good job. Now, that doesn't happen very often, but that is a right that's provided to members to deal with those types of situations.
And Jackie, can the other board members remove the director if they don't think they're doing a good job?
No, it's just a membership decision. You always have to go back to the members. Now, it may be that your corporation is what we call a closed membership corporation. The directors and the members are the same people. So in that situation, the directors could put their hat on as members, call a members meeting and remove that person from the board. But if you have a broad-based membership, then you have to call a full members meeting, and those members would have to decide to remove the director from office. The board cannot do it on its own. The only exception is that there's some objective criteria, like the person in question has declared bankruptcy or they're not capable of managing property, then they're automatically ineligible to continue to be a director.
Okay. So thanks, Jackie. And so there are lots of good questions here, but I'm going to pick one more that's just dealing with a bit of a post-transitional issue.
Sure.
And so this is in the event that a client has multiple classes of membership, which are only provided for in the bylaws, and they have not completed a transition, So that is they haven't applied for articles of amendment or anything like that. How does this impact their membership?
The multiple classes of members would continue. You would prepare new ONCA documents. And if you want to continue to have multiple members, and then you would include the details of that in the articles. If you wanted to get rid of the multiple classes of members and revert to one class, you'd have to include that in the articles, but you need to remember that you're going to have to bring those ONCA documents to your existing membership structure, and that will include the multiple classes. They have to have a right to vote to make a change to those membership classes. And if they don't want to, then you may be stuck with that, and you would have to reflect the same in your articles of amendment.
Okay. Well, thanks very much, Jackie. We can't get through any more questions, but we want to thank everyone for attending today's webinar or any of our previous spring webinar series. If you have been to our previous in-person webinar seminars before and you've missed seeing us, or you've never seen us, and you want to see us in person, come celebrate the 25th anniversary with Carter's at the return of our in-person Carter's annual charity and not-for-profit law seminar on Thursday, November 12th, 2026. The special guest this year will be Bruce McDonald, President of Imagine Canada. This year's seminar will be held in a hybrid format with both an in-person session, so you can come down and see me and Jackie, for all presentations taking place at the 1250 Event Center located at 1250 Markham Road, Toronto, together with the option to join remotely as a live webinar through live streaming of the in-person session. Stay tuned for more details or sign up for our monthly newsletters at carters.ca for updates. So thanks, Jackie, again for your practical advice and tips today. And we couldn't do these webinars without our support team of Brenda Parsons, Sunil Patel, Jennifer Kirkow, Selena Nathu, and the many other people at the firm that help contribute to these different webinars. Thanks for attending today, and we hope to see you in the future.